day, welcome to our oral presentation. Today we will be discussing the topic of whether or not Section 97 of the Malaysian Child Act 2001 is a good law. Hi, my name is Faye, and before we go into the discussion, I will be going over what exactly is the Child Act of 2001, as well as the brief history on how it was enacted. The Malaysian Child Act of 2001 is aimed at ensuring the protection, survival, and development of children who is any persons under the age of 18, by acknowledging their rights to life, recognizing that every child is entitled to help and care in any situation or circumstance, regardless of race, gender, religion, etc., and upholding the child's best interests. This act also recognizes that every child deserves respect, as they're not only a crucial part of society, but also recognizing that they are responsible for development and prosperity. The Child Act also states that a child's development and growth rely heavily on the role and responsibility of their family, which means, as a society, it is important to acknowledge this to provide the child with a healthy and supportive environment in order for the child to obtain confidence and dignity as a human being. Now, how did this act come to be? After being approved by Parliament in 2001, the Malaysian Child Act was put into effect in August of 2002. Because of the changes to the Criminal Procedure Code and Penal Code in 2001, it took the Malaysian Parliament 3 years to approve this document. This legislation repealed 3 prior acts: the Child Protection Act of 1991, the Women and Girls Protection Act of 1973, and the Juvenile Court in 1947. As mentioned earlier, one of the main goals of this act is to normalize and clarify the definition and age of a child, to straighten out the responsibilities and duties that should be performed by the child's legal guardians, and to implement a higher level fine imposed on any offenses committed under the act. From the time of colonization until 1963, when Malaysia gained its independence, the country's social policy has worked to establish a global human rights framework. Changes in child welfare policy were sparked by Malaysia's strong participation in the worldwide human rights movement in the late 1980s and early 1990s, particularly after Datuk Seri Anwar Ibrahim was appointed as Deputy Prime Minister. After Malaysia achieved 45 years of independence from the British Empire, the Malaysian Child Act was enacted. The act consolidates 3 prior legislation that addressed several facets of child welfare, as mentioned earlier, those being the Child Protection Act of 1991, the Women and Girls Protection Act 1973, and the Juvenile Court 1947. The Malaysia Child Act passage in 2001 brought about a paradigm change in how child welfare is constructed. The primary purpose of the act was to fulfill the government's attempts to support worldwide social policy, human rights, and technological advancements, in addition to acknowledging local demands. Thank you.
The legal framework surrounding juvenile justice is a complex interplay of protecting the public while ensuring that the rights and developmental needs of those who have committed an offense under the age of consent are met. Sections 97(1) of the Children Act 2001 in Malaysia embodies this delicate balance by exempting individuals under the age of 18 from the death penalty, recognizing the basic principle that children, by virtue of their age, have a greater opportunity for reform and rehabilitation. This decision reflects not only Malaysia's commitment to maintain the norms inherent in international human rights agreements, but also the awareness of changing the standards and justice in society. The basis for such laws is based on legal and ethical principles and draws on a rich tapestry of legal philosophy and also psychological knowledge and culture values. When determining whether Section 97(1) is a good law, it is crucial to examine its compliance with the international norms, effectiveness in accomplishing its intended goals, and flexibility to adapt to shifting lines of social and legal thinking. The debate should be informed by a thorough review of the relevant articles, statute provisions, and court opinions that have influenced the interpretation and application of this legislation. As we begin this analysis, it is important to understand that the laws governing juvenile offenders are not only about punishment, but rather about shaping a better generation that can contribute positively to society. From this perspective, we can critically evaluate Section 97.1 and explore ways to enhance its strengths or suggest amendments to enhance its effectiveness.
Malaysia, being a country where Islam is the official religion of the Federation by virtue of Article 3, Clause 1 of the Federal Constitution, consists two systems of laws, which is civil and Islamic law. The main laws which govern juvenile justice are the Child Act of 2001, Penal Code, and the Criminal Procedure Code. For Muslims, Sharia courts, for example, we have the Criminal Jurisdiction Act 1965, Sharia Criminal Offences of the Federal Territories Act of 1997, and the Act of 1997. So at what age a child should be held responsible for his acts? According to Section 82 of the Penal Code, an act of a child under 10 years of age is not an offence. However, Section 2 of the Child Act of 2001 defines a child to be below the age of 18 years old. Under the Security Offences or Special Measures Act of 2012, or better known as SOSMA, the age of responsibility is set to 18 years old and above. For Sharia criminal offences of 1997, the attainment of puberty is the age of responsibility. The Sharia Criminal Procedure Federal Territories Act of 1997 defines a youthful offender as between the age of 10 to 16 years old. So international treaties which are concerned with children's rights are the Convention to Eliminate All Forms of Discrimination Against Women, Convention on the Rights of the Child, Convention on the Rights of Persons with Disabilities. The Malaysian government had ratified these treaties above and the Convention on the Rights of the Child. However, these treaties are only applicable if it's in line with the Federal Constitution and the laws which exist in Malaysia. The treaties cannot be invoked unless it had been adopted by local law. So minors should be accountable for their own actions and wrongdoings. However, they cannot be punished with the same punishment as adults. For example, offences such as murder and drugs. This is said so because a few studies conducted by universities had proven that a state of mind of a minor hasn't been fully developed as an adult. According to a study by Harvard Medical School and the National Institute of Mental Health and the University of California Department of Neuroscience, found that the frontal and prefrontal lobes of the brain, which regulates the impulse control and judgment, are not developed entirely among minors. So these developing parts of the brain is only attained upon reaching the age of between 18 to 22 years old. So is the law above good? So in my opinion, based on the studies conducted by various universities across the globe and upholding international conventions which are concerned with children's rights, I believe that a child should not be punishable to death for crimes which are punishable with death, such as murder under Section 302 of the Federal Constitution and drug trafficking under Section 39B of the Dangerous Drugs Act. This is said so because of the difference between the state of mind of a fully grown adult and a minor. Minors shall be placed under detention with the goals of rehabilitation and ensure when the minor leaves prison, he will become a better citizen. So based on a study by Nanyang University of Singapore, the cognitive abilities of the human brain are the vital parts of the brain which develop skills, understanding such as learning, memorizing, problem solving. The cognitive abilities between fully grown adults and minors are not the same, hence why adults are able to use more cognitive ability to think. Minors, however, use their sensory experience to learn and understand from their surroundings. In addition to that, a child should not receive death penalty due to compliance with international treaties and conventions. Under Article 37A of the Convention of Rights of a Child, or CRC, it prohibits the execution of persons below the age of 18 years old. Some other treaties actually prohibits the death of penalty for children are the International Covenant on Civil and Political Rights, the Second Optional Protocol of the ICCPR, and the African Charter on the Rights and Welfare of the Child. Malaysia ratified the Convention on the Rights of a Child, or better known as CRC, and shall continue to prohibit the execution of a child 18 years and below. Even though Malaysia had already prohibited minors from death penalty since the year 1990, the government should amend existing laws to prevent contradiction between various laws. For example, I personally think that the government should amend the Penal Code Age of Responsibility. Section 82 of the Penal Code stated that an act of a child under 10 years old of age is not an offense and should be amended to act of a child under the age of 18 years old can be considered as a crime, however, shall not be punished to death if the offense is related to crimes which is punishable with death penalty. In addition to that, under Article 5 of the Federal Constitution, a provision which prohibits capital punishment for children shall be added to prohibit children from death penalty.
Hi, my name is Divya, and today I am going to be talking about whether the Section 97(1) of the Child Act 2001 is a good law or a bad law. In various legal systems, there is a recognized necessity to treat children and adults differently, especially regarding severe punishments. Section 97(1) of the Child Act 2001, which bans the death penalty of children, marks an important advancement in this area. In my opinion, this section is a good law grounded in moral, ethical, and international legal principles. However, to ensure its effectiveness and consistent application, certain enhancements are necessary. The ethical implications of sentencing children to death are profound. Due to their development stage, children possess a higher potential for transformation and rehabilitation than adults. The principle of giving children a chance to reform is fundamental to a humane and compassionate society. Sentencing children to death ignores their potential to rehabilitation and violates fundamental human rights principles. International treaties and conventions strongly support the protection of children's rights. The United Nations Convention on the Rights of the Children, UNCRC, which Malaysia has ratified, clearly forbids the death penalty for crimes committed by individuals under the age of 18. This can be viewed in the Article 37 of UNCRC, which states no child should be subjected to torture or other cruel punishment. Neither capital punishment nor the imprisonment without possibility of release should be imposed for offences committed by individuals below 18. According to the case of Public Prosecutor and Koh Wah Kwan, the federal court held that the mandatory death penalty could not be imposed on a child, emphasizing the need for special considerations for juvenile offenders. This can be viewed similarly in the case of Public Prosecutor and Loo Chun Fat. Loo Chun was convicted of a serious offense that he had committed while he was a minor. However, given that he was under the age of 18, the court had considered the application of Section 97(1) of the Child Act 2001. The case serves as a precedent for how courts should handle similar cases involving juvenile offenders in serious crimes. It reinforces the principle that the death penalty should not be applied to children, aligning with the international standards such as UNCRC. One of the ways to strengthen Section 97 of the Child Act 2001 is to clarify the term children in the context of the Act. The terms need to be defined as any person under the age of 18 at the time of the offence. This aligns with the international standards such as UNCRC, which helps ensure all legal proceedings recognize any individuals under the age of 18 as a child, thereby applying the protection intended by Section 97 of the Child Act 2001. Other than that, there is insufficient emphasis on rehabilitation and reintegration.
The court shall ensure that any child convicted of an offence is provided with an access to rehabilitation and reintegration programs, including psychological support, education, and vocational training. This amendment emphasizes the importance of rehabilitation over punitive measures, ensuring the juvenile offenders receive the necessary support to reintegrate into the society successfully. This can be concluded that Section 97(1) of the Child Act 2001, which prohibits the sentencing of children to death, is a fundamentally sound and just provision within Malaysia's legal framework. This law embodies crucial moral, ethical, and international legal standards, reflecting a commitment to the humane treatment of juvenile offenders. By recognizing the distinct development stages and rehabilitation potential of children, Section 97(1) aligns with global human rights principles, including those enshrined in the United Nations Convention on the Rights of the Child. In summary, Section 97(1) of the Child Act 2001 is not only a good law, but also a crucial step towards ensuring that children who come into conflict with the law are given the opportunity to reform and reintegrate into society, reflecting the highest standards of justice and human rights.
Good day, I am Zitia Arisha and I'll be giving my opinion whether Section 97 subsection 1 of Child Act 2001 is a good law or not. Section 97 subsection 1 of Child Act states that a sentence of death shall not be pronounced or recorded against a person convicted of an offence if it appears to the court that at the time when the offence was committed he was a child, and it simply means Section 97 subsection 1 prohibits the death penalty for a child offender convicted of a serious crime. This provision also recognizes the special status and vulnerability of children and ensures that they are not subjected to the harshest form of punishment. So, how and to what extent should a child be held accountable for his actions? What sort of punishment is appropriate for a child who has committed a serious crime? And what should be the purpose of criminal sanctions? Brian K. Lawrence, the director of Britain's Criminal Justice Association, once stressed that doing nothing to those who are caught should not be an option. If they are not taught that such behavior will lead to their being punished, is society not letting them down as much as itself? This is not to say that juvenile sentences should not have a rehabilitative aspect. In the United States and Britain, violent acts of crime by children have been increasing in dismaying proportion. In Malaysia, the Parliamentary Secretary to the Women, Family and Community Development Ministry revealed alarming figures since 2004. There were as many as 18,334 convictions of criminal offences involving children aged between 10 and 18 for theft, robbery, extortion, housebreaking, drug possession and trafficking, gambling, firearms, illicit sex, rape, illegal racing and prostitutions. The prevalence of such crime by children has provoked certain countries to apply the death penalty to them. According to Amnesty International report, since 1990, 9 countries, China, Congo Democratic Republic, Iran, Nigeria, Pakistan, Saudi Arabia, Sudan, US and Yemen have executed 53 prisoners who were under 18. The US and Iran have each executed more child offenders than the other 7 countries combined. I am quite aware that the law does provide for a lesser sentence or no sentence at all imposed upon a person of young age. There has however emerged in recent years in our society certain species of crimes which the clarity of mind and body, the dare and defiance of youth alone is capable of performing and producing. Law cannot, in my view, remain merely a static and a meaninglessly ornamented and an orthodox instrument of justice, ineffective in its result and application. The social needs of the times have to be met and effectively met. It is not merely the correction of the offender which is the prime object of the punishment. The consideration of public interest have also to be borne in mind. In certain types of offences, A sentence has got to be deterrent so that others who are like-minded may be restrained from becoming a menace to society. Nonetheless, a balanced approach dictates that a child who commits murder should not be allowed to act with impunity. Neither capital punishment nor life imprisonment without possibility of release shall be imposed for offences committed by persons below 18 years of age. Regarding the possible punishment that can be passed against a child offender, Section 97 subsection 2 of the Child Act 2001 provides a range of alternative measures that can be taken instead of imprisonment or other forms of punishment. These alternative measures aim to rehabilitate and reintegrate the child into society. Some of the possible punishment include: firstly, placement under the care of a fit person or suitable institution; secondly, attendance at a rehabilitation center or any other suitable program; third, participation in community service or counselling; and lastly, provision of supervisions and guidance by a provisions officer. In addition, Boudin 2010 also explores the attitude of the judiciary that is too hard on the child offenders and do not utilize the provisions of orders based on the theory of rehabilitation in Act 611. As a result, more child offenders are being sent to prison or receive stiffer punishment. According to Boudin, there are children aged 14 and 18 years whom are in jail for offences that range from the minor offences to serious offences. Although members of the judiciary issued an order based on the background of the child offender and the type of offence committed, Boudin argues that the best interest of the child is more important than other aspects of punishment. Recognizing that every child is entitled to protection and existence in all circumstances without regard to distinction of any kind such as race, colour, sex, language, religion, social origin, or physical, mental, or emotional disabilities, or any other status. I also acknowledge that the family as the fundamental group in society which provide the neutral environment for the growth, support, and well-being of all its members, particularly the children, so that they may develop in an environment of peace, happiness, love, and understanding in order to attain the full confidence, dignity, and worth of the human person. I also recognize that the role and responsibility of the family in society, that they be afforded the necessary assistance to enable them to fully assume their responsibility as the source of care, support, rehabilitation, and development of children in society. Therefore, in my opinion, Section 97 subsection 1 of Child Act 2001 is a good law because it is important to note that the focus of the Child Act 2001 is on the welfare and best interests of the child, with an emphasis on rehabilitation rather than punishment. The aim is to provide support and guidance to help the child develop into a responsible and law-abiding individual. That's all from me. Thank you.
Hello, I'm Skylar. In Malaysia, the legal landscape that governs juvenile justice comprises a nuanced framework encompassing the civil and also the Islamic laws, which presents a complex scenario for addressing the issues of holding children accountable for their acts. Statutes such as the Child Act 2001, the Penal Code, the Sharia law, they delineate the age of responsibility for child offenders, and then several questions arise concerning the imposition of the death penalty on minors, especially in cases where we can say that a child might have committed a very serious offense, like maybe they are involved in crime like murder or drug trafficking. Numerous international treaties ratified by Malaysia, like the Convention of the Right of Child, underscore the significance of protecting minors from harsh penalties like the death penalty. Despite the existing prohibition on executing child offenders in Malaysia since 1990, the need for legal reform to ensure consistency and alignment with global human rights standards remain paramount. Our essay contains that minors should not face death penalty due to factors such as their cognitive development, the international obligation, the imperative of rehabilitation over retribution in the juvenile justice system. If we look at legal precedents like the principle established in Roper and Simmons, a landmark US Supreme Court case underscored the global trend towards recognizing juvenile diminished culpability and also the inherent immorality of imposing harsh penalties on youth. So by aligning Malaysia legal framework with these evolving legal doctrines and international standards, the country can affirm its dedication to protecting the rights and well-being of minors in conflict with the law. To conclude, I will say that the legal prohibition on subjecting minors to death penalty and advocating for comprehensive legal reform to safeguard juvenile offenders in Malaysia, it is not only a moral imperative, but it is also a legal responsibility that aligns with the international human rights norm. By embracing the principle of juvenile justice that prioritizes rehabilitation and individualized children for child offenders, Malaysia demonstrates its commitment to upholding inherent dignity and also the rights of all individuals within its jurisdiction, particularly the rights of the most vulnerable members of society, which are the children. Thank you.
And lastly, here are our citations with both primary sources and secondary sources. Thank you so much for your time.